It was an excellent deal, but
That's fine. I just want you to know that after today, I will accept no plea agreements.
There's a certain moment in court when everything shifts. You can feel it. The judge's patience is thinning. The defendant thinks he's explaining himself, but is actually digging the hole deeper. And what makes this hearing different is that the deal on the table wasn't small. It was 10 years to wipe away multiple serious felonies. Let's watch how this unravels.
it's mandatory, right?
But not mandatory.
If you want to go to trial and not accept a plea agreement, then listen to your attorney and do what he's telling you to do.
Okay, so basically it's completely off the table right now, the plea?
Yeah.
Right there. And there.
What's all this?
Defamation, man. They've been gaslighting me for 5 weeks straight. Been doing my best to get to the population going on and try to stay out of trouble. They all up on the microphone.
All right, this is, stop talking. This is cause numbers 24 DCCR 1500, 24 DCCR 1614, 1615, 25 DCCR 0436, and you're Traylon Hill.
Yes, ma'am.
And Mr. Hill's charged, let me go through this, in cause number, the first one, 1500, with obstruction or retaliation. Do not do that again.
My apologies.
Who's in here for him?
My grandmother.
All right. Ma'am, can you move over to that back corner so that he cannot see you and be distracted? Thank you for being here.
What you're watching here isn't just a judge being irritated. This is a pattern. When a judge says, "You just don't know how to behave," that's not about one outburst. That's about accumulated reports. Jail conduct matters. Jurors hear about it. Prosecutors use it to show character and credibility. And instead of demonstrating discipline, he's arguing about being bullied and misunderstood. But here's the problem. None of that excuses documented misconduct.
Mr. Hill, you just don't know how to behave, do you?
I apologize.
Saying you're sorry doesn't matter. This is nonsense. Since we were here last time, I don't even know how many more pages of the nonsense that you've been doing in our jail.
It's gaslighting. It's solicitation.
Okay.
And I've been trying to stay out the way. I've been getting bullied over the microphone. I have inmates there encouraging the inmates to harass me, calling me punks, alpha, profit, plenty of things. Gangster play, mad,
Yeah.
mortar. Man, I'm just trying my best to stay out the way.
Okay.
I got a job, I got a home, an actual home. I don't stay in apartments or anything like that. My mama actually owns rent houses. And you know what I'm saying? I'm actually trying to take care of the family business. And my dad's 76 years old.
Yeah.
My best to stay out the way.
Well, it doesn't look like you are.
Yeah, it's tough in that facility. It's a war zone.
So one of the time you're running back and forth, playing like a little kid in the day room.
I work out.
Who made you do that?
I'm a boxer. I work out.
Are you allowed to do that in the jail?
In the rec room? Yes, ma'am.
Okay, so are you allowed to do it in the other room?
I have a one-man cell in the facility.
Are you allowed to do that?
Yes, ma'am.
You are?
I'm not running freely throughout the facility or anything like that, but I do work out a lot every day.
So who made you dash?
This moment is surreal. He's facing aggravated robbery and aggravated assault charges, offenses that can carry life in prison. And when asked why he keeps making comments to female officers, he says, "I'm a lover boy." That's not charm. In court, that reads as lack of impulse control. Judges aren't just evaluating the charges. They're evaluating whether you can follow rules, whether you respect authority, whether you grasp the seriousness of your situation. And right now, he doesn't seem to.
Dash the floor with water.
Everyone in that facility has a water.
Who made you dash the floor with water?
I'm not the only one. That was
Listen
me.
to my question.
No one did.
No, but you did it on your own,
Yeah,
right?
but it wasn't
Nobody's,
okay.
stop talking when I'm talking. I'm going to ask you some yes or no questions.
Okay.
So nobody's making you do those things, right? Nobody bullied you into dashing water, right? Yes or no?
Yes, ma'am.
Okay, hold on a second. What about Why do you continue to make comments to the female officers out there? Why do you think that's okay after you've been told not to do that?
Sitting in the cell all day long, man. When I see that get hurt, I'm a little boy. I admit that.
Because you're a lover boy?
Yes, ma'am.
So you understand that part of all of this trouble and you not being able to get your cases worked out is because you can't follow that rule.
Yeah, I hate that.
Did somebody bully you into being that way to those officers?
In a manner, you know what I'm saying? When
Oh, yeah?
I'm dealing with these stressful inmates, you know what I'm saying? I love to be around mom.
Okay.
I'm a mama boy.
Judge, based on his Sunday night activity, I'm pretty sure there'll be a new case coming.
Yeah.
I've got to call into the investigator for the sheriff's department to find out
Okay.
when they'll bring that over. But I would ask that we go ahead and set these in for trial.
This is where confidence turns into overconfidence. When the judge warns that a jury will hear about jail behavior, she's telling him, your credibility is on the line. And he responds like it's an episode he can narrate his way out of. But juries don't grade storytelling. They evaluate consistency, remorse, and responsibility. Arrogance in that moment, it rarely lands well.
And we've already talked before about the fact that everything that's happening, a jury is going to know about all that. You understand that? Okay. And do you think that's going to help you or hurt you when a jury hears how you're behaving in the jail?
When it comes down to video footage and how I explain it, I think my efforts will be pretty good.
You think so?
Yes, ma'am.
You think, let's go through real quick before we do this rejection. And cause number 241500, you're charged with obstruction or retaliation. Is that a third?
That is a third, Your Honor.
Third-degree felony, which means if you're found guilty, the range of punishment is between 2 years and up to 10 years. Do you understand?
Yes, ma'am.
And cause number 24 DCCR 1614, you're charged with aggravated assault with a deadly weapon. And second-degree felony offense, which means the punishment range is between 2 years and up to 20 years in prison if you're found guilty. Do you understand that?
Yes, ma'am.
And cause number 24, DCCR 1615, you're charged with aggravated robbery, which is a first-degree felony, which means if you're found guilty, the range of punishment is a minimum 5 years up to life in prison. Do you understand?
Okay.
And then in 250436, you're charged with burglary of a habitation, which is a second-degree felony. The punishment range in that is between 2 years and up to 20 years if you're found guilty. Do you understand?
Correct.
I have here on the computer.
Let's pause here. Aggravated robbery, 5 years to life. Aggravated assault with a deadly weapon, up to 20. Burglary, up to 20. Obstruction, up to 10. And remember what she said earlier about stacking sentences. If convicted on separate dates, those sentences can run consecutively. That means one after another. 10 years suddenly starts looking very different.
Plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilt for a 10-year term in prison on a lesser offense of robbery.
Of robbery and dismissal of the other charges.
You have every right to reject that.
It was an excellent deal, but
That's fine. I just want you to know that after today, I will accept no plea agreements. A jury is going to decide, because I don't know that I even agree with this. So today's the day. If you want to take it, fine. If not, you're going to trial. A jury will decide if you're guilty or not. And then if you are found guilty, that jury will determine what your punishment is. And is that what you want to do?
are all these charges going to be on one trial?
They don't necessarily have to be, because you've
Your
got
Honor,
3 different dates.
Your Honor, the robbery and aggravated assault are the same offense day. I'd expect to try them together.
Okay, so what can happen is you will, it sounds like the aggravated assault and the aggravated robbery will be tried together.
This is the turning point. It was an excellent deal. Judges don't usually editorialize plea offers. When they do, it means they see the risk clearly. 10 years on a lesser robbery charge. All others dismissed. After today, off the table. That's the gamble. Trial means uncertainty. And uncertainty in felony court can be brutal.
It's important that you understand also, if you're found guilty on those, then the state can also try you later on one or both of the other cases. If you're found guilty on those, because the offense dates are different dates, there is the possibility that any sentence that a jury gives you could be stacked or run consecutively. Do you understand?
Right.
Okay. All right, we'll get it set for trial. Go back with the bailiff. Good luck, Mr. Burbank.
Thank you,
I don't know that I've ever been so mad at a defendant. I mean, can't help it. Kevin Ross, Mr. Burbank.
I mean, you know we started with
Yeah. It's gonna keep on getting worse because the jury's gonna. And there's no paperwork on Mr. Ross, right?
I do have a bond.
I don't know that I've ever been so mad at a defendant. Judges are trained to stay composed. When you hear that level of visible frustration, it means something deeper happened here. It's not just about the charges. It's about courtroom conduct. It's about missed opportunity. It's about watching someone potentially trade a fixed 10-year sentence for the possibility of decades, or even life. Court isn't a stage. It's not an episode. It's consequences. And sometimes the most dangerous decision isn't what happened on the street. It's what happens when you refuse to read the room.
You are Jimmy Taylor?
Yes, ma'am.
And Mr. Taylor, you were previously in court, entered pleas of true and a motion to revoke your unadjudicated probation. Counts 1, 2, 3, 4, 5, and 6. You pled true to all of those counts. You're on probation. The second-degree felony offense of theft of property with previous convictions with findings that prior offenses were true. You were placed on that probation January 24th of 2024. I have received the pre-sentence report, as well as there was one incident report from the jail, a page that should have been sent to you all, and also Mr. Coleman has also provided a copy of the court's sentencing hearing, a transcript from that original sentencing back on January 23rd of 2024. Has everyone had an opportunity to review all of those things?
We have, Your Honor.
The state has, Judge.
Are there any additions or corrections to that updated report?
Not from the defense.
Not from the state, Your Honor. There are a couple of things I'd like to speak to if and when the court would like to hear from you.
Yes, of course. So let me just, there's no agreement in this, correct? This was just open to the court?
That's correct, Your Honor.
Yes, Your Honor.
And, all right, Mr. Rojas, you may proceed.
Thank you, Your Honor. We're going to be asking for the court to continue Mr. Taylor on probation. I know by looking at the PSI on paper, it doesn't look like there's a chance that Mr. Taylor should be given, especially given his criminal history. It looks like his criminal history is all in some way related to drug abuse. If you look at the allegations he pled true to, those are the non-compliance allegations have to do with drugs. And the reason for not complying with the JCBI program, he doesn't come from a wealthy background. He doesn't have a whole lot of affluent friends and family members that can help him out. He had a ride with his brother. His brother had an accident, and that option was not available to him anymore. He indicates to me that he does want help getting off of the drugs, and I'm sure that when Mr. Coleman has a chance to speak, he's going to point out the comments made by the court to this defendant about not wanting to hear about needing more help with drugs or any relapses.
I really don't, because here's the thing, Mr. Johnson. I'm looking back at your original pre-sentence report that when I put you on probation, and I make notations on those reports and make highlights and those types of things. And I'm noting that in that report, you already, before this case, had gone to ISF and SafeP. And then on this probation, I sent you to ISF at the beginning of the probation. Is that correct or no?
I believe parole sent him to ISF.
Yes, ma'am.
So you were on parole.
Yes, ma'am.
I gave you a probation against Mr. Coleman's wishes and really against what looked like I should have. You went to ISF regardless of who. So you've been to ISF twice. Is that correct?
Should be.
You're looking at her. You've gone. Have you been to
Yes, ma'am. I've
ISF
been
once
there
or twice?
How many times?
How many times?
Twice in 20 years.
Okay, so you've
Well,
been,
I've been in prison 23 years out of the last 30 years. So I've been doing my time and
but you
I
keep
haven't had
getting,
a chance to.
to do what? Because you've been to SafeP, you've been to ISF, and you went to ISF more recently, right?
Yes, ma'am.
Okay.
As soon as I got out, I got it right on probation. And I haven't had a chance to.
You got right on probation. You didn't.
Yes, ma'am.
You
Then I
tested.
had to go to Beaumont, which
You
I'm
tested
from,
positive
so
for
I-
cocaine
Yes,
after
I
all of
understand.
this time, and all the different things that have been given to you, and the opportunity that I gave you back in January of last year. You pled open, just open to me. I could have done
Yes, I did.
anything.
Yes.
I could have sent you to prison for 20 years, 10 years, and I gave you an opportunity. And I said on that day, because Mr. Coleman printed it out for
I know
me,
what you said.
well,
Ma'am.
so how do I do anything other than what I said?
I mean, it's a situation. I've got parents. My mother's 90 years old, man. I don't want her to die and I be
Hey,
in prison.
we're not talking about anybody
You
but
know,
you today.
Yeah, I know.
I'm sorry your mom's that old and that you
Yeah.
haven't been around to be with her, but that's whose fault? It's not going to be my
I
fault if
understand
you're
what
not there.
saying, but
How about some personal responsibility instead of my mama's
that's
old
what
and
I
don't
would
send me
like
to
do,
prison?
ma'am, you know.
Judge, what I was saying about this.
Go ahead.
He was warned about not coming back, and the court didn't want to hear about a relapse, but I don't know that this is really a relapse. He never really got the help. On this most recent term of probation with the JCDI, and if transportation is gonna be a problem, I know he's already been to SafeP, Judge, but it would be the relapse, portion of SafeP would be appropriate, or a whole new term.
Hold on. So if I'm reading this, I want to know when he went to ISF this last time. Parole sent him when, because the way I'm reading is you were released from ISF and started JCDI August 6th of 2024. So I put you on probation in January, and between January and August, you went to ISF last year. Is that correct or no?
Parole sent him to ISF because of this new charge.
Okay. So when was that?
He was in custody, Jefferson County,
Mhm.
and then from custody.
Went straight there.
parole,
So I placed you on probation, you never got out, you went and got help at ISF. Okay, all right, anything else?
And Judge, if the court, and it seems like the court is not leaning towards probation.
No. No,
I would point out, we understand the range of punishment is up to 20 years, but the bottom end of that range is 2 to 20. And
I still haven't done anything yet, so your response and how you act right now is gonna go into what I do.
Now, I understand the legislation makes it possible to go all the way up to 20, but it also makes it possible to go down as low as 2. I think we have to look at each case for the facts, and the underlying offense was a theft at the Dollar General, I think, or Family Dollar, I think it was about $100 worth of merchandise. I would ask the court to consider something at the lower end of the range, maybe 2 to 5. Just because we can drop the hammer on them, that doesn't necessarily mean that we should. And that's what we're asking the court to do. Probation is not going to be an option.
Thank you. Mr. Coleman?
I'll keep it brief. The defendant has earned every bit of a 15-year sentence in prison. That's what I asked for originally. You placed it on deferred. That's what I'm asking for today. 3 things I'd like to quickly point out, Your Honor. Looking at the defendant's version in the updated PSI, he says that when he was placed on in the JCDI program, that he believes it was an attempt to set him up for failure, demonstrating a lack of acceptance of his own responsibility. The resources and time that have been dedicated to this defendant, limited resources, mind you, could have been redirected to someone who is more amenable to being rehabilitated. Lastly, you got his full criminal history there in the original PSI. And I provided you with the transcript from the sentencing just to remind the court. I know you see a lot of defendants, but just to remind the court that you essentially told him up front this was essentially a zero tolerance probation.
And I do appreciate that because I do see a lot and I don't remember it all. But Mr. Taylor, do you have anything you want to say?
Yes, ma'am, you know, been through a lot of things in my life, you know, people dying in my family and other things, drugs, but, you know, I think, you know, that I could do better if I had a chance, proper opportunity, ma'am. And I did a lot of time, I've done my time.
You have.
I don't think just putting me in prison I think I need a chance, I really do.
It doesn't make any sense because you're saying, you know, you've done a lot of time and at some point you either say, I don't like prison and I want to do better.
That's what I want, man.
But you didn't take advantage of the opportunities you were given. You're saying you want help and we gave you help or parole gave you help. So you didn't even get out on my probation yet. You had ISF, a reminder of the tools that you had a long time ago. You had those things and you got out and you didn't take advantage of the opportunity that I told you. You better take advantage of it because you're not going to get it again. You're saying the same things that you said. Please just give me another chance. I'm going to do better. Please send me to ISF or a safe P. It's all the same thing that you're saying, and no one is setting anybody up for failure. Hang on.
To the JCDI. I had back surgery.
So what you're telling me is when did you have back surgery?
8 years ago.
Okay.
But they only did half.
Listen.
I'm not making excuses.
If you're throwing out to me that you had back surgery 8 years ago, then you are digging for everything you possibly can, and we're done with all that. I'm going to find that you previously entered your pleas of true to counts 1 through 6 freely and voluntarily. I'm going to find those counts true. I'm going to find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property with previous convictions. I'm going to sentence you to a term of 12 years in the Institutional Division of Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you trial court certification that shows this was not an agreement. You do have some limited rights to appeal. You can talk to Mr. Rojas about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. Y'all need to sign that, and he'll give you a copy of it. Thank you. Thank you, ma'am, for being here. Ms. Holmes on Demario Flukas. Hey, come back, Mr. Taylor. Come here. Let me tell you something. I still have jurisdiction over your case. So any disrespect that you show me right now, I can add years to that number. Is that what you would like to do? I do think it's fair. It doesn't matter that it's a misdemeanor. You keep doing it over and over. Go back with the bailiff. And you probably should keep your mouth shut this time.